Okay. Thank you, everybody who is trickling in now. We're just going to give it a minute or two to let people trickle in. This is the webinar on the future of the immigration courts. I'll be doing some intros. Let me just, in a few moments, just as people start coming in. Amazing. All right. Well, it looks like we already have a good number of people here. Excuse my dog in the background. My name is Mazen Sid Ahmed. I am one of the co-executive directors of Documented. We are a nonprofit news organization that covers immigration in the New York area, and I'm so excited about today's event. This is the latest in a series of events that we call Documented Talks, where we try and convene experts and leaders in the field to talk about the most pressing issues about immigration. And today we have a really exciting conversation for you. Contributing writer Julia Preston will be interviewing Immigration Judge Amiena Khan about the future of the immigration courts. Before I get into their bios and introductions, I just wanted to let you all know a little bit about Documented. As I said, we're a nonprofit news organization covering immigration in the New York area. And we're really driven by support from our readers and our members. If you'd like to know more about our work, we'll be dropping information in the chat. You can donate to us and support us to allow us to keep doing work like this in the future. And we'll be dropping more information about that in the chat as well. So to get us started, I'm going to introduce our incredible panel. Please excuse my dog has found something very interesting in the background. First of all, Julia Preston, contributing writer at the Marshall Project. She previously worked for 21 years at the New York Times. I'm sorry, I'm just going to have to attend to that. I apologize.
That's all right. I can introduce myself.
Okay, yeah, if you wouldn't mind introducing the Judge Khan and going from there, I'm just going to go and sort out this issue in the background.
Terrific.
But really honored to have you both here.
Thank you, Maz. And I'll let Julia introduce herself, and I'm happy to introduce myself as well. Thank you.
Okay, sounds great. I'm Julia Preston. I'm a contributing writer at the Marshall Project. I worked at the New York Times for 21 years. For 10 years of that time, I was the national immigration correspondent for the New York Times. And I've been writing about immigration or the countries that send immigrants for most of my career. So I'm very honored to be here today with Judge Khan.
Thank you. Good afternoon, and thank you, Mazen and Julia, for inviting me to speak today. Before we begin, as I am an employee of the Department of Justice, I have to provide the following disclaimer. I'm speaking in my capacity today as the president of the National Association of Immigration Judges. The views that I express are my personal views and opinions, which were formed in consultation with NAIJ membership. They are not the official position of the U.S. Department of Justice, the Attorney General, or the Executive Office for Immigration Review. My name is Amiena Khan. I'm an immigration judge seated in New York at 26 Federal Plaza. I've been an IJ since December of 2010, and I cover a non-detained docket. I just quickly want to share and thank you and Mazen for inviting me today. And I've been watching as the attendance numbers grow, as I mentioned to you. And so as the numbers grow, my anxiety has also grown exponentially, but I am rewarded with the understanding that there is interest in this subject, in the interest in the integrity of our courts and the future of our court system. I find that extremely gratifying. We all work together to ensure transparency, accountability, and integrity of our court system and process. Again, I had the pleasure of meeting Mazen at a FBA New York Law School co-sponsored asylum conference, and I have had the pleasure of having many conversations with him. And as our simple conversation between himself and myself grew, I am gratified and welcome the opportunity for me to be here with you, Julia, as such an accomplished journalist with the Marshall Project. So thank you.
Our conversation today is going to proceed until 1:45, a conversation between myself and Judge Khan, and then we'll open up for questions. We did receive some questions ahead of time, and I'm going to incorporate some of those into my conversation. Judge Khan, the court and the immigration court in New York is now fully open. And the New York court, as I'm sure you're aware, has the dubious distinction of having the largest case load, the case backlog in the country, having surpassed Los Angeles. And so I'm wondering, what are you seeing now that the court is fully opened? Is it order? Is it chaos? How would you describe how the functioning of the court now that it's fully reopened after the closure from COVID-19?
So our non-detained dockets at 26 Federal Plaza and a number of courts across the nation resumed hearings after a period of pause due to the health crisis and pandemic. We resumed operations on July 6th. From our perspective and the court perspective, the rollout was orderly. The notices had been sent out previously. All of the team members, the staff, the immigration judges, the court management worked tirelessly and hand in hand to ensure that adequate notice was afforded and that the understandable anxieties of those individuals returning to court, not only the non-citizens that appear before us, their counsel and representatives, the trial attorneys and immigration judges and our staff, but that we all work together to ensure that that anxiety and the level of anxiety was reduced. We are on a rotation schedule at 26 Federal Plaza. Half of the workforce comes in 1 week and the other half of the workforce comes in accordingly during the other week. And that's for the purposes of trying to ensure social distancing. We recognize that we remain in a pandemic and health crisis. We recognizing the changing pandemic and the contours of the pandemic. And we are working to ensure that we can continue with our hearings utilizing tools such as WebEx technology, video conference hearings, allowing both counsel, non-citizens, as well as the trial attorneys with the Department of Homeland Security to appear via VTC as necessary, pivoting to telephonic when absolutely needed, though that is not preferential because of our concerns as well as the counsel's concerns with due process. But in my experience with regard to the hearings that I conducted, the hearings went very smoothly. I had no issues. Of course, on the first day of each week, there were some technological glitches. And so where does that take us with respect to the technological glitches? Well, that is in effect because our agency is behind in technological development and modernization. Our union has been advocating for increased resources to develop technology and resources to increase bandwidth and to ensure that individuals that do appear before us using this VT technology, that it is consistent and that it enables us to ensure due process and fundamentally fair hearings go forward.
I'm wondering, where are you setting out to these days? I mean, a person who is, is scheduled for a merits hearing, your judges, how far out are they setting with that kind of caseload in the court?
Well, in our court right now, we are scheduling, our judges are scheduled out to December of 2023. The agency has put a cap on our ability to schedule further than December of 2023 at this juncture. Other courts and other judges across the nation are scheduling out to 2024. We have a court out in New Orleans that's scheduling out to 2025. So anyone that would appear before us in a new matter at a master calendar would be scheduled at least out to 2023, if not beyond. And that, of course, is concerning. Any delay is of concern for non-citizens who have waited for their day in court. Now, we understand the realities of the health crisis, the global health crisis that we've all endured, and we understand the requirements that were put in place at the behest of the union and with great difficulty with the prior Trump administration in enforcing temporary pauses to ensure the health and safety of immigration judges, our staff, all court participants in the greater community. It was an uphill battle from early on in February of 2020, and even obtaining recognition that the pandemic was ongoing. So I say that because when we consider why the cases had to be adjourned or delayed because of those concerns, I think it's a reasonable expectation that those matters were not able to be going forward. However, that being said, it's still crucial for management to be able to allow judges to control their docket so that we can put these matters back on the docket as quickly as possible. We do have the benefit of additional hiring and additional judges that will afford us the opportunity to move some of the dockets for judges that most judges in our nation have upwards of 2,000 to 2,500 cases on their docket to begin with. Some judges have far in excess. And what that creates is also a delay in being able to have matters go forward and heard. The last 2 weeks showed, I believe, the judges as well as management, that when we control our dockets, when we schedule accordingly the cases that we believe that can go forward, which we were allowed to do in New York at 26 Federal Plaza, that we can get those matters concluded efficiently and allow individuals to come in to court and have their day in court. We fully recognize the stress, the anticipation felt by those that are seeking relief before immigration courts, those that are seeking asylum. We recognize that justice delayed or the delay in having those cases go before us can lead to unjust results. Evidence becomes stale, witnesses that individuals rely on for their hearings and to meet their burdens of proof move, get lost, become unavailable. Country conditions change. We are extremely cognizant of the fact that individuals have family members who are in their home countries who may be at risk. And so we look at multiple factors when we are choosing to go forward, and we implore the agency to allow immigration judges to control and manage our own dockets for efficiency and effectiveness. And when we are allowed to do so, the cases that we schedule before us go forward. Julia?
Let me ask you about that, because on July 15th, we had a decision from the Attorney General that I think was significant in that regard. As you know, the Trump administration took a series of decisions that really restricted the flexibility of immigration judges. And one of them was in a case called Castro-Tum. And on July 15th, the Attorney General Garland basically reversed that decision, canceled that decision. And what this does is allow the immigration judge to, as it's referred to, administratively close a case. Now, this is maybe a level of mind-numbing complexity for people who aren't practitioners in immigration court or who are not immigration judges. Maybe you could explain why this is a significant decision, even though it sounds like a sort of procedural, fix.
Well, Julia, thank you for bringing that up. This decision was extremely, extremely important. A well-founded decision on the part of the Attorney General. NAIJ welcomes the decision of the Attorney General in Cruz Valdez. This allowed, as you noted, the restoration of the use of a valuable docket management tool by immigration judges, and it acknowledged the importance of decisional independence of immigration judges. The Attorney General, by recognizing that administrative closure, when appropriate, is within the authority of immigration judges, has set the course for us to more effectively and efficiently address the enormous backlog faced by the immigration courts, which, as you may know, is upwards of 1.3 million. Administrative closure was not a procedural nicety. I'm going to use a phrase by author Alison Peck, who noted that depriving immigration judges of this very important tool could lead to the removal of non-citizens with rights to lawful residence under our immigration laws, forcing our judges to go forward on relief applications when they knew the non-citizens had alternative forms of relief pending outside of our jurisdiction, such as alien relative petitions, was an infringement on the rights of the individuals that come before us. It was an effective tool to put forward the prior Trump administration's restrictive agenda. And it was an all-out, let me see how I can, it was an all-out attack on immigration judges by the prior Trump administration in taking away our tools to effectively manage our dockets, in undermining our decisional independence, in disregarding overall the rule of law. It's extremely important to recognize that all of us, participants and judges, we can never allow expediency and efficiency to turn our courts into assembly lines. And that's exactly what the prior Trump administration effectively attempted to do, to enforce their agenda and to use the Department of Justice as a mechanism to weaponize our courts. And taking away that one a tool from us undermined the process effectively. It kept individuals, without getting too much in the weeds, individuals from obtaining relief to ensure family unity under I-601A waivers, which would allow individuals to waive unlawful presence in this country, those that had been sponsored by family members, but could not adjust according to the law within our nation. They had to go outside and do consular processing to come back. They did not even have a mechanism to avail themselves of that waiver because of the taking away of this particular tool from us for administrative closure. And what does the tool allow judges to do? How does it help us minimize the backlog? It allows us to take our cases that are not ripe for adjudication and pause them, right? We're not terminating them. They're not concluded, they're paused, so that the individuals in the cases that are paused that have alternative forms of relief that are out of our jurisdiction to adjudicate, such as alien relative petitions or specific waivers that we don't have jurisdiction or authority to review, allow USCIS or other agencies within Department of Homeland Security to address those applications, and so that they then can avail themselves with regard to the alternative forms of relief. Instead of, when the administrative closure was taken away from our jurisdiction, instead of forcing these individuals or non-citizens to go forward with relief applications when they had alternative relief applications. So this decision is extremely significant and impactful, and is another tool in our arsenal to allow us to manage our dockets and decrease the backlog in doing so.
And are you immediately empowered to start closing those cases again? I mean, is it a return to what, the status quo ante, or what's the situation with that?
Status quo, and as of the date the order went into effect, I am able to close cases administratively, sua sponte, if necessary. Of course, we work with the Department of Homeland Security and their ability as well to effectuate prosecutorial discretion. When I say that, in terms of working to minimize and diminish the backlog that we see across the nation as a whole, our union welcomes very creative solutions to the process, recognizing that that means intra-agency cooperation, recognizing and welcoming the reprioritization of enforcement policies, welcoming back the opportunity for prosecutorial discretion to be effectuated by Department of Homeland Security attorneys. And so administrative closure now will be recognized again as being an opportunity to close cases or in the alternative to terminate cases. Prior to this decision being rendered by the Attorney General, one of our concerns was that although we welcome prosecutorial discretion back to enable the trial attorneys to review matters, to seek dismissal of matters that were not in line with the current enforcement policies. There were glitches. We were concerned about non-citizens who did not have work authorization or would lose work authorization by the termination of their proceedings, as they would have no pending relief applications before us. And nobody wants to create a tertiary a group of individuals in our society that are not able to work legally and support themselves. And within the shadows of our society as individuals without status.
Another measure that the Trump administration took was to impose performance quotas on the judges. And I received a question actually from one of our participants on this subject. She says, this is Emerson Argueta. She is a young immigration attorney in Long Island, and she's working with a team of pro bono attorneys. And she says, now that EOR has resumed non-detained hearings nationwide, I had hoped that IJs would have flexibility with the nonprofit bar in working with us to resume merits hearings. She says, we do not have a way to communicate the immense burdens new policies like enhanced case flow processing has placed on us, as we get deadlines imposed on us without the opportunity to point out our obligations in other matters. And so she's asking, are the quotas still in place? Is the reason why the IJs are rushing these cases along to that makes it very complicated? She says, is the NAIJ aware of the tremendous burdens we are facing in the pro bono bar because of this fast pace of action, and whether the quotas that were imposed by President Trump are still in place? So are they?
They are. And this is one of our great concerns. Many of our concerns remain in place under the current administration, and our union continues as well, notably to fight the decertification action. With regard to the quotas and performance metrics, we all recognize the abuses of the prior Trump administration to effectively speed up the workforce, to attempt, as I noted earlier, to create a sort of an assembly line justice, assembly line processing of our cases, rather, to enhance efficiency and removal orders. The quotas and metrics were put in place during that time period in 2018, and they remain in place today. The speedometers that were put in place under the Trump administration, red, green, and yellow speedometers, are still there. And the agency is continuing to collect the statistics and the data by the agency, and using resources that could be better used in other areas of management towards managing these quotas. We all recognize that these quotas should be removed. They should be absolutely abolished. We all recognize that because of the pandemic and the period of pause that many of our colleagues, that it would be nonsensical to apply the quotas to the numeric performance metrics, to judges' performance in terms of evaluating our performance. But our agency, EYR, has never said that to immigration judges. They've never addressed the fact that there is no purposefulness behind quotas and numeric performance metrics. We have to recognize that when individuals come to our courts, that we are the face of we are the face of the U.S. judicial process. We are the first courts that they see, and we recognize that our nation stands for welcoming and protection for those in need. We have to ensure that our immigration courts are able to function with accountability and transparency. The numerics that were put in place, unfortunately, wrongly tied our performance and our decisions to our livelihood. Questioning and putting in place a question to the very foundation and integrity of our process. That has not changed. That remains in effect. Our responsibility for immigration judges is to adjudicate the cases before us as neutral arbiters. We look at the facts, we look at the law, we look at the precedent set by the BIA and circuit courts. There should be no consideration tied into our review of the matters before us and the decisions that we render to meeting goals, quantitative goals. There isn't a judicial system in our nation that uses quantitative measures, numeric measures, to measure individual judge performance. So we're not against the use of completion goals based on review and judicial values. Goals are necessary for the management and the agency to measure functioning performance of policies, to keep a track and be able to recognize where enhancements are needed, where work is needed, where there is insufficient support. But to tie the decision of a judge to a numeric goal is just inherently contrary to the judicial principles that we all believe and know that stand in our nation.
The Biden administration, the Attorney General, also recently reversed two other major decisions by the Trump administration in cases that involved asylum seekers who were seeking relief on the basis of a sexual or domestic violence claim or a claim associated with a close family member. I understand that you probably are not in a position to give an opinion as to whether these cases were rightly or wrongly decided either by Trump or by Biden. But I'm wondering if you see that these rulings in the matter of AB and the matter of LEA, are they going to have an impact on the work of the immigration judges?
Of course they will. And thank you for recognizing that I can't comment on substantive law or litigation. What we saw under the prior Trump administration is that with the politicization of our courts and the overreach rather, by the administration in place at the time, that the number of decisions that were self-certified to prior Attorney General Sessions and prior Attorney General William Barr, I mean, they increased substantially. I think at least 17 decisions were rendered in that way. And it was a tool effectively, again, to put forward the restrictive agenda of the prior administration. The mechanisms that were already in place were the appropriate mechanisms for review of immigration judges' decisions by the Board of Immigration Appeals, and then, if necessary, for non-citizens, by review by the circuit courts. For the prior administration, their use of manipulating case law, what it did and how it burdened our courts and our immigration judges is that the process became inherently more litigious. And so the expectation of attorneys and counsels to zealously represent their clients meant that they had to put forth additional arguments, put forth additional particular social groups, create a record for review by the Board of Immigration Appeals or the circuit courts. And so it added additional factors into our process already in place that delayed getting to more complex matters that one would spend more time on because every case became complex by the certified cases that we were discussing that were recently overturned by the Attorney General. And so that change in posture of these precedential cases negatively impacted our ability to move along our cases and to work collectively to strive to diminish the backlog.
Another thing that the Trump administration obviously did was, I think it's fair to say that the Trump administration had it in for the NAIJ, and they mounted a quite aggressive campaign to decertify the union in what I think was a transparent effort to silence you and other representatives of the judges from bringing forth the issues that we're talking about today. Absolutely. And so bring us up to date. Where does it stand now with the decertification of the union and your efforts to fight that?
Sure. Well, I'll just make a quick comment on what you said. Our immigration judges and our union was absolutely under attack by the prior Trump administration. We were targeted in retaliation for being forceful advocates, for being the voice of our members and calling for change and transparency and accountability. And to quiet us, what they did was they mounted the attack in August of 2019 by filing a representation petition to decertify the immigration union. And so where are we right now with our fight against the decertification? Our challenge with the decertification struggle is not yet over. Our fight is not ended under this current administration. First of all, NAIJ has received tremendous support from the Hill, representatives, senators, the Labor Caucus, national unions, well-respected legal organizations and scholars, all in support of our right to continue as a union and collective bargaining representative, and also on our behalf, reaching out to the Attorney General and calling for a withdrawal of the decertification position. We are grateful to all of these groups and organizations for their ongoing support and recognition of the principle of the right to the union to act on behalf of their membership. By way of background, as you know, the petition was filed. Subsequently, a decision was rendered by the FLRA, as you noted, on November 2nd, on the eve of the election, November 2nd, 2020. You know, what better way to sort of hide that decision, right? By having it overcome by the events of the day, of the election. Day.
There was something else going on that day.
Something else going on, that's right. And by that decision, the FLRA found that our members, they ruled that our immigration judges are management officials, and under the Federal Service Labor Management Relations Statute, they were not eligible to be part of a bargaining unit. The decision that was made reversing almost 40 years of precedent, and the authority in rendering that decision did not follow their own precedent. The action, the decision of the FLRA served to chill and pause all unions in terms of future possible decisions for membership, who is or who is not a management official. By what terms does one become involved in policy-making process? NAIJ strongly believes that the decision was erroneous.
I think the Biden administration took a step recently to, didn't they withdraw from their position?
Yes, yes, they did. So going further, I just wanted to point out that it was abundantly clear in the decision. It was a 2-to-1 majority by the FLRA authority, and the dissent was very strong in calling the decision of the authority the antithesis of reasoned decision making. And he concluded that it was abundantly clear that the majority's sole objective was to divest our immigration judges of their statutory rights. Subsequently, NAIJ filed a motion to reconsider and for stay, which we had the statutory or regulatory rights to do so. That matter is pending. Litigation is ongoing. The Department of Homeland Security recently filed a motion of non-opposition to our motion for reconsideration and stay. Prior to them filing that, NAIJ was extremely perplexed as to why there was a lack of response from the Department of Justice and from the administration, taking stock of the current position, welcome position of President Biden's administration. We welcomed the executive orders. We welcomed the position on by the administration in respecting the rights of federal employees to organize and be a part of collective bargaining units. We respected the administration's position on having employees work with the management with respect to ongoing discussion of health and safety measures within the agency and within the courts or within the particular component. So when we observed these welcomed executive orders promoting collective bargaining and worker organizing and empowerment, and most recently, very welcome provision for increasing diversity, inclusion, and accessibility, we were perplexed why the Department of Justice was not responding and why they were continuing with their stance in opposing and going forward with their decertification action. However, as I noted to you, we were pleasantly surprised and very welcoming of their filing on June 25 of their motion in non-opposition. And most recently, on July 19th, the agency by motion has sought leave to withdraw their representation petition. And so to NAIJ, it appears that the agency is no longer making arguments for decertification of the union and is no longer in opposition to our argument that the authority's November 2nd decision was incorrect. So it's important to note, though, that we're encouraged by these filings by the Department of Homeland, excuse me, by the EOIR and DOJ. Our current posture remains, as I noted, the same. We are not recognized as a union. Our contract continues to be repudiated by the agency. We can't determine what the next steps will be for the FLRA. It would be peculiar, in my mind, for the authority not to grant our motion for consideration, but that's a guess on my part. At this juncture, the Washington Regional Director's decision, our position is that it was absolutely correct, and that the prior decision threw out 40 years of precedent without explanation, as I noted, or following their own precedent, and that our arguments to dismiss are absolutely correct. However, EOIR continues to take this position and fails to recognize us. And the agency has taken this action while we were in the middle of litigation and in the appeal process, and they short-circuited this process by failing to recognize us. And so, Julia, what the union did is to protect our legal rights. We've been put in a position where we had to file unfair labor practice charges with the enforcement branch of the FLRA, or the Federal Labor Relations Authority. The acting general counsel has found several of our unfair labor practice charges are with merit, including two of our most important filings, which is the agency's failure to recognize us and repudiation of our contract. And so this means that our members were prematurely designated not to be members of a bargaining unit. They've not been able to exercise their Weingarten rights. What are Weingarten rights for those who are not familiar with union concept? But those are the rights afforded to our union members to be represented by the union local representatives at any investigatory interview that they may have with their supervisor, when the employee reasonably believes that they may have some disciplinary action taken. We haven't had our rights and ability to go forward with grievances on behalf of our membership. We haven't had any rights afforded to us to bargain over the impact and implementation of policies on our working conditions that have been put into place. One of your questionnaires asked about the case flow management policy and being overwhelmed by that. Our position is that that policy was put in place in violation of the terms of our collective bargaining agreement, and we have filed an unfair labor practice because our union was not afforded the opportunity to bargain and negotiate over the impact and implementation of that policy on our working conditions.
Okay, so it sounds like you're still waiting for more action by the Biden administration to make this effective. I think you just had an election, didn't you?
We did.
You have something to announce about that?
Thank you for reminding me.
I will say we have a lot of great questions here, so.
No, we'll keep going with the questions.
Let's hear the announcement here.
Sure. Well, our union has elections every 2 years in odd years. Our election period recently ended, and we'll be having a change in leadership. We have a new incoming union president, Judge Mimi Sankoff. Our new our vice president-elect will be Judge Sam Cole. And our other board members will remain in place. We are welcoming of a new Eastern Region Vice President, Holly DeAndrea, who is seated in Conroe, Texas. Our Secretary Treasurer is Judge Dorothy Harbeck, and our Western Regional Vice President is Don O'Hare. And so we just got those results on July 16th. Those results were announced. And so there will be a change in leadership.
We have a couple of questions from people who are attending about the new immigration judges who've been named. And there's a feeling that, there's certainty that the Trump administration tended to look to people who had law enforcement background or had been ICE counsel prosecutorial role, look to those people for to choose them as immigration judges. And some of the people in the audience feel that the Biden administration is continuing that practice. And so I understand that. I guess the question I would ask, does the NAIJ have a position on the qualifications for immigration judges, or do you have any view about the background that would be ideal for an immigration judge?
Well, NAIJ strongly supports a diversity in hiring and a diversity in the pool of applicants that are considered for the position of immigration judges. We've always strongly believed in diversity of hiring, not only in experience, but of attributes that are essential to have our courts represent the society that we live in at large. All of these factors need to be reviewed carefully. Every hire and every immigration judge brings a great wealth of background experience and view to the bench. We welcome the hiring of our colleagues. We are recognizing that our immigration corps has substantially grown. It doubled under the prior Trump administration. I believe the prior Trump administration was able to bring on about 214 immigration judges. We are now have about approximately 500 immigration judges nationwide, 67 immigration courts, and 3 adjudications facilities. It is welcome information to hear that through resources that additional immigration judges will be brought on board. We welcome new colleagues to assist us in ongoing efforts to diminish the backlog. Hiring immigration judges alone is ineffective to diminish the backlog. We recognize that there is a great need with hiring of immigration judges to hire immigration teams as well. One of our greatest concerns is that the past administration failed to do that, even though they were appropriated income and budgets that when they did hire immigration judges, that they were also supposed to use those resources to hire teams. What are immigration teams? Immigration teams are legal assistants, legal technicians, judicial law clerks, language specialists, which are our interpreters, human resources personnel, which is extremely important as well, and BIA staff attorneys. That's one definition of what a team should be, and the resources needed to be expended adequately or concomitantly with the hiring of our judges so that we can effectively work together and not to draw away resources, insufficient resources for our immigration judges that are already in place. One of our great concerns was that a lot of this hiring was done indeed without hiring adequate teams. And so what did that result in? That results in and has resulted in insufficient staffing, insufficient support, and insufficient resources in our immigration courts, which adds to the backlog, adds to the inefficiencies, and is not conducive to meet the mission of the agency as a whole. All of us who are participants, our immigration judges, our staff, we're all part of a team to make sure that we move the mission of the agency and the goals of our system of law to ensure that the non-citizens that come before us have their opportunity to have their day in court, to have their matters heard, to put forth their defensive applications and to get a decision. What happens when you don't have sufficient resources to allow you to go forward? Examples are files are not pulled, files are lost, insufficient resources led to lack of space and facilities for new immigration judges. A lack of resources has led to the inability to modernize our technology and resources. NAIJ, since early on in the pandemic in early May, had been advocating for our agency to be able to pivot to the needs of this emergency, to rely on greater technological resources, to incorporate remote hearings where necessary, so that individuals could continue to have their cases heard. Ultimately, our agency did put forth a trial pilot project. Both judges in Newark, New Jersey, and in Los Angeles, California, were able to go forward with a pilot project doing remote hearings. I can unequivocally state from speaking with the judges that it's been a very successful pilot. The productivity levels are high, and there have been minimal to no concerns in terms of due process. And so are remote hearings what we wish to have for our future? Well, I think you can temper that. The gold standard is to have in-person hearings without question. And the objective and the requirements are that we protect individuals' due process rights and ensure that a fair hearing is provided. But if we can develop and ensure a process to do so, when emergency situations such as this pandemic arise, then it is a benefit to all of us and to society as a large. Our concern for the union, again, is that as this pilot project program is increased and expanded, our union has to have an opportunity to work with the agency, to work with EOIR in making sure that sufficient protections and parameters are set in place for our judges who will be utilizing this technology and remote opportunities. You know, it was extremely interesting. Our agency was ill-equipped to pivot at the time in 2020, where other state courts and federal courts were easily able to adapt. We were not. What we did is the prior administration had, for the most part, the majority of our courts continued to function. Our judges in our detained courts were at work. Those proceedings continued without pause, except for COVID closures and exposure. So I think that the delay was a missed opportunity, and now there is a great opportunity to focus resources on technological development. Our agency has worked or moved towards establishment of an electronic case and appeals filing system. We are far from being a paperless society or paperless court, which is what we're striving to get to. But that involves sufficient resources to put towards development of those technological technologies and methodologies. NAIJ we have chairs who are our tech chairs who have been part of our union for years and years, who need to be a part of the development as we continue on with the establishment of the ECAS system in our immigration courts. I believe the courts are now, I believe the agency is at 78% of our courts are ECAS enabled, and the majority of our courts, if not 100%, have WebEx capability. However, the NAIJ, we've seen that there's problems. We've seen that there's inherent issues with judicial tools, with the ability of immigration judges to utilize these resources efficiently and effectively. And what we need to do is we need to be back in the seat as a union, recognized collective bargaining representative for our membership, so that we can advocate and work with the agency together to better the processes going forward.
We have we have a number of questions about the independence of the immigration courts.
Terrific.
And the idea of Congress creating an independent immigration court used to be kind of impractical fancy until the Trump administration came along and basically trampled on the independent of the immigration judges and the court system. So how do you see that now? What are the prospects? How do you,
Sure.
you know, is it still totally impractical, or do you
Well,
think?
Let me address that, Julia, and thank you for asking that. First of all, what the Trump administration did is it displayed by the abuses on our system, it displayed the vulnerability, right, of our process and our system. It exposed the inherent structural flaws that we all knew were there to begin with. Many of our suggestions and remedies that we recommend, rather, serve for the most part as band-aids on issues and wounds that have not been able to be addressed. You know, when you mentioned, and I'll get to our independent court immediately, but you mentioned that the abuses of the Trump administration, they trampled on our decisional independence. I want to point out that wasn't just the Trump administration. It was prior administrations. All administrations in the time that I've been on the bench, both Democratic, both Republican, have used our courts as tools to put forth their political agendas. There was, in previous administrations, there was the surge of individuals coming from our southwest border, or what we thought of as rocket dockets.
Right.
And what that resulted in was a aimless shuffling of our dockets, right? So as individuals were put in front, the individuals unfairly who were already there were then put at the end of our dockets.
Since you raised that,
Sure.
I mean, we did have a question from Talco Pan, my journalism colleague, who I have written a lot about this. She's written a lot about this. What a disaster this was for the docket. And now the Biden administration has done it again.
Well, yes and no. So yes and no. So the Trump administration did start a FAMU docket, which was very similar to the surge docket. And interestingly, the folks that were pushed forward on our surge docket were then the same individuals that, when the new administration under Trump put forth the Family Matters Unit docket, their cases were then put at the bump to the end of the line so that these new individuals could go forward. It's nonsensical. That is not how any court should function. And you mentioned under the Biden administration, yes, there are new dockets, they're activated dockets. The difference with these dockets are that these cases are not being, they're dockets that are going forward at mostly detained courts because of the drop in numbers at the detention facilities. They are not displacing individuals already on our docket.
I see. Okay.
Many of the individuals coming from the southwest border were allowed to move into the interior of the United States, reach out to family members, and then go to courts where the impact was less felt. So once these individuals come to our courts, then we're able to schedule them. But
I didn't mean to, that was a detour from your conversation. Yeah, I didn't mean to waylay you with that.
Right. Well, I mean,
I'm
gratified to see that with respect to the Biden administration. I applaud this administration's commitment to diversity, labor, and unions, and his stated belief in the rule of law. We have to hold this administration accountable as we would any other administration. There is an understanding that we need to ensure that our processes are able to function without overreach, without encroachment. And
can you do that within the current system? Within the Justice Department, can the immigration courts really be truly independent?
Well, I believe that the history of our immigration courts and the needs of our immigration court system lead us towards not only adherence to judicial principles, but to the sustainable solution of an independent court. Our courts, as I noted to you, cannot be allowed to be political pawns. They cannot be used as tools for enforcement agency or a politically driven agenda. We need to strive to protect against this politicization of the process. And to do so, we have to look towards a solution of an independent court. This is our long-term or our future goal, is to have an independent immigration court established based on judicial principles and protected from the changing political winds. And as I noted, insulated from political overreach and influence. We strongly believe, as I noted, that our immigration courts, like our justice system in our country, needs to be fair and impartial. What the inherent structural flaws within our system were present, as I noted to you, and available for exploitation by the Trump administration, and allow other administrations to put forth, if we see the change in political winds, another restrictivist type of policy. And so, as I noted, we need to learn from our examples of history. We have to look at the years of past abuses exemplified by the actual change going forward needed to address the systemic problems left behind by not only the Trump administration, but systemic issues that predated the Trump administration. I just want to know.
Is there any prospect? Do you see any prospect of this?
Well, we do. Well, you know, EOIR has failed to implement, as I noted, many of the points that we've addressed, that NAIJ has been calling out, failing to properly provide resources and electronic filing systems. And all of these problems really flow from the structural flaw. Where are resources provided, right? When you're in the Department of Justice, who gets the lion's share of resources, right? And correctly so. For if you're running an enforcement agency, it's got to go to your enforcement personnel, right? And who we support. Of course, we support law personnel. However, your courts can't be starved of resources. And so the inherent flaw of being housed in the Department of Justice has to and can only be addressed by the formation and creation of an independent immigration court. You know, again, I referred to Alison Peck earlier, and as well as the president of the ABA, Judy Martinez, made an excellent comment. Alison Peck said that creating an independent Article 1 immigration court system wouldn't change our underlying immigration laws or DHS's right to enforce the laws. It would simply ensure that individuals before the courts in the United States receive a fair hearing sheltered from the shifting winds of politics. And so we are where we are now. We've been working closely with the FBA, AILA, the ABA on comprehensive immigration reform. We've been gratified by the support, again, of over 125 national unions, legal organizations, scholars who have supported us in calling and reaching out to Congress for the establishment of an independent court. I'm pleased to say that we are aware that Chairwoman Lofgren and a cohort of senators are working on a bill for an independent court. We're hopeful for the introduction of the bill before the end of the year. I understand that the bill is possibly to create an Article 1 immigration court. I don't know what it is based on. I have not seen a final draft of that bill, whether it's based on a tax structure. But I think it's very important for all of us to note that in listening recently to the Attorney General's testimony before the Senate Appropriations Committee, I was very pleased to hear during this testimony when he was questioned by Senator Shaheen that given the immigration courts are not independent like the federal court system, there are a lot of organizations like the Federal Bar Association who've argued they should become Article 1 courts. He was questioned, do you support leaving them the way they are, or would you advocate to make them a separate system? And our Attorney General commented that that's an issue that he hadn't thought about with respect to the way in which to structure this. He does think, or rather I do think, that the courts should be as independent as possible. I understand that this was the reason in the Homeland Security Act that they were taken away from INS, Immigration and Naturalization Service, the legacy service, which went to Homeland Security, and the courts were left with the Justice Department, within the Justice Department. At one point, they were all together at the Justice Department, and that was an effort for security, for independence. I believe that immigration judges should be left alone to do their work, and they are, of course, subject to review. The question of whether they should be in Article I court and completely independent is really a question for Congress, and that he would be happy to think about it more.
All right, well, I think we have to leave it there.
Well, I wanted to read his words because I found them powerful. I found them instructive, and I found them to lend to our optimism that consideration of the development and scheduling or a bill being introduced for the creation of an independent court may be at hand.
Okay, thank you.
Wow, what an incredible discussion.
But you know, before I let anyone
might as well end on an upbeat note.
Okay.
Absolutely.
We will.
Yes, my dog is fine. Thank you for asking. It just found something.
He didn't want to wait for the question and answer.
I know. He was like, Judge Khan, let's go.
Let's go. Let's hear.
But that was really an incredible conversation. I just appreciate your candor and honesty, Judge Khan, and thank you for the amazing questions and moderations, Julia. Judge Khan, we did have one question about whether or not people could follow up and ask you questions. There was a lot that we didn't get to. Obviously, we're fully aware of your disclaimer, so we understand if things fall outside of your purview. But if there are things within your purview that you can answer, could we forward some of these questions to you?
Absolutely, without question. I'm happy for anyone to reach out to me. I'm happy to discuss many aspects of issues that were raised today. I'm always happy and perhaps too talkative about the vulnerabilities of our system and about looking forward in our future. I always think it's extremely, extremely important to remember that our immigration judges do exceptionally well on the bench. They strive to maintain their oath of office, and every day they go into court ready to ensure that due process is provided and that fundamentally fair hearings are conducted. I think that it's extremely important to remember that all of us, our judges, we strive to remember that the rule of law prevails and that we must always consider the humanity of the individuals that appear before us and never forget sight of that fact.
Thank you so much for that, Judge Khan. So we'll definitely be following up with you on that. And once again, can't thank you enough for taking the time today. That is our program. Once again, we are documented. We'll be hosting conversations like this, hopefully each month. Please sign up for our newsletter. If you want to support this work, there you can find the link in the chat to give a donation or become a member of Documented to keep this work going and empower the work that we do. Once again, thank you, Julia. Thank you, Judge Khan. I much appreciate it. Have a great day, everybody.
Thank you, Mazen.
Thank you. Thank you,
Julia. It's been a pleasure.
Yeah, for me too. Thank you very much.
All the best.